2015, the board approved the transfer of the CPG to BHC Solar LLC. Beach Club Properties, DBA Basin Harbor Club, has not been the holder of their certificate of public good since that time. The installer is AllEarth Renewables, as I mentioned in my notice of appearance here. AllEarth has, because it signed the application with Mr. Goodyear on behalf of Beach Properties in 2014, has provided the supplemental information on the historic sites analysis and that kind of thing. So it's not, I've not filed a motion to intervene on behalf of AllEarth Renewables because the board has taken the position, at least in another case involving an installer's responsibility for the applicant, that they weren't allowed to intervene. When all is said and done, AllEarth is responsible for the, will be responsible for paying any penalty that would be issued as a result of the mistake in the application that was filed, or the letter that was filed back in, I think, March by Dimsey on behalf of Beach Properties. So Mr. Goodyear is here, as I understand it, and speaking with his boss, Bob Beach, through voicemail tag, because they're named. They were served with a copy of it, but they're just the off-taker and landlord. They no longer are the certificate holder as of February of last year.
Okay.
So I don't know how, I don't know really what you want to do about all that.
Yeah, well, I mean, I think what we'll do is we can go on the record and you can go ahead and repeat that, and then we can get the department's take on it, on if they have any recommendations about next steps. And
Great.
we can chat about intervention and things like that, and then maybe we might have to do a little reset. There are some basic things I want to chat with people about, though, that I think we can, well, actually, let's
go on the record.
Just, yeah. So,
Thank you very much.
okay, let's go on the record. Good morning. This is a pre-hearing conference in Public Service Board docket 8692, an investigation pursuant to 30 VSA sections 30 and 209 and Public Service Board Rule 5.110D into the accuracy of information supplied on an application for an interconnected group net metered photovoltaic electric system in Ferrisburg, Vermont, filed by Beach Properties, Inc., DBA Basin Harbor Club. My name is John Cotter. I'm a staff attorney at the Public Service Board, and I've been appointed to serve as hearing officer in this proceeding. I want to note, I believe we have two interested persons attending by telephone today, being Elizabeth and Mary McGuire. Are you there?
Yes, we're here. Thank you.
Okay, thank you. Welcome.
I'm sorry, was that Mary or Elizabeth speaking?
We're both here.
Okay, who's speaking though?
This is Elizabeth speaking.
Thank you.
So let's start out by taking appearances, please. Department.
Jeannie Elias for the Department of Public Service.
Gail Azaria for the Division for Historic Preservation, and with me is Laura Treishman, the State Historic Preservation Officer.
Leslie Cadwell on behalf of AllEarth Renewables, the installer of the solar project at issue.
Brian Goodyear, Basin Harbor Club.
Thank you. Ms. Cadwell, before we went on the record, discussing a few what you characterized as procedural snafus. If you'd like to go over those on the record, and then I'd like to at least get the department and perhaps the Division of Historic Preservation's responses to those, and perhaps even Mr. Goodyear as well, if you have a response to them.
Thank you very much. Well, first on February 12th, 2015, the board approved the transfer of the Certificate of Public Good in dockets CPG NM 5006, which was the docket that granted the Certificate of Public Good for the solar array at issue. The transfer was approved to BHC Solar LLC. The installer is AllEarth Renewables, and following the board's March 19th, 2015 memorandum to Beach Properties, DBA Basin Harbor Club, AllEarth followed up with some filings responding to comments and engaged experts on historic structures and archaeological sites to perform the historic sites review that should have been done prior to the application being submitted, and remains available to pay and is ultimately responsible to, in its arrangements with Beach Properties, its landlord and the applicant, original applicant, to pay any penalties that might come out of the proceeding. We've not yet I've filed a notice of appearance. I've not yet filed a motion to intervene in light of the Public Service Board's order in docket 8446, in which the installer was denied intervention in a Section 30 investigation, and we just await some guidance on how to proceed. We would like to offer up our assistance in any way to get the case resolved, the case being 8692, this docket.
Okay, I'm sorry, could you repeat the name of the docket number that you cited to where the board disallowed intervention by an installer?
8446.
Thank you. That's what I
La
thought.
Jeunesse Interior, Inc.
Okay.
In that case, the installer was Catamount Solar, who made the very same argument that they are responsible for the penalty, but the board denied intervention.
Okay. And I guess I'm not asking you because you have not yet filed a motion to intervene, and I'm not sure where this falls in terms of your actual client's interest, but I'll ask you your understanding then. Is it your understanding that the current CPG holder, BHC Solar LLC, is a necessary party to this proceeding? Even though the events that are being investigated took place before that entity was the CPG holder?
I don't know the answer to that question. I haven't done the legal research to as a legal matter. I know that they are aware of it because we provided them with a copy of it.
When you say it, you mean the order opening the investigation?
Thank you. Yes, the order opening investigation. Correct.
And they must have just chosen on their own accord not to show up today then?
Well, I can't really speak to that. The order, there was no process served on from the board on anyone, but as far as I know, me believing I was counsel for Beach Properties.
Right.
So I don't know the answer to that. I've not been in contact with BH Solar other than to pass along the information.
Okay.
But they are the CPG holder, and they were the CPG holder when, in March last year, when the board asked for comments and when the case went on appeal.
Okay. Fair enough. I appreciate that you informed them and gave them a copy. Just to correct, I know that the clerk's office did, after receiving your notice of appearance and your cover letter, did actually serve a copy of the order opening of the investigation upon Basin Harbor Club. Department, any insights here?
No insights, a couple of reactions. The department is very familiar with the board's precedent with respect to developers being part of penalty investigations from docket 8446, and would think on that basis that the board might likely deny intervention to Ms. Cadwell's client in this proceeding, but should AllEarth Renewables elect to file a motion to intervene, the department would respond at that time. However, I did read the board's order in 8446, and even though its decision on the intervention was brief, I think the logic was correct and remains correct, although I reserve the right to look at any motion that Ms. Cadwell files and review it and respond. With respect to the transfer of the CPG, I certainly think that the initial applicant is an appropriate party, but the discussion has raised a concern about the array of sanctions available to the board and who they would affect. So for example, revocation of the CPG would not affect Basin Harbor Club beach properties since they're no longer the holder of the CPG, but it would affect the current CPG holder. So I wasn't aware of this issue ahead of the proceedings today. Would like to give us more thought, but put that out there for the board and the parties that to the extent that there are sanctions that are available to the board in a 30 VSA 30 proceeding, to the extent that they could have an impact on the current holder of the CPG, that should shed some light on whether it's appropriate to make the current CPG holder a party and responsible for the actions of their forefathers, as it were.
Okay. I appreciate those thoughts. Mrs. Area, any thoughts?
I don't think we have anything to add at this time. We haven't studied this issue enough.
Okay. Yeah. Mr. Goodyear?
I think just to add is that AllEarth Renewables and the representatives from AllEarth Renewables were the ones that actually filled out the application, went through what we figured was the due diligence when doing that. There were some questionnaires some questions from Tim Reynolds to myself discussing some of the areas that I think Mr. Berger addressed in a letter to the board. And at the end of the day, he gave me a signature page. I signed it, I scanned it to him, and then he included that as part of the permit itself. So, myself as a representative from Beach Property, we're certainly utilizing or assuming AllEarth's, that they have their stuff together and that they filled that application as they should. Basin Harbor has never been involved in any type of permitting process like this for CPG. We basically saw an opportunity to do some type of additional renewable on our property as part of our strategic plan, and AllEarth came to us with an opportunity to be able to be the off-taker and then also the lease for the project.
Okay, I appreciate that. Ms. and Ms. McGuire, I believe the clerk's office alerted you to the fact that you would not automatically be a party to this particular proceeding, but I did want to inquire as to whether or not you actually intended to seek party status by filing a motion to intervene.
I think we will be filing a motion to intervene, yeah.
Okay, and I understand you're familiar with the board's website, so you know how to find the board's rules on intervention on the website, and you understand that if you do file a motion to intervene, that you need to serve hard copies of that file a hard copy with the board and serve hard copies of that to everyone on the service list?
Yes.
Right, okay.
Thank you.
I was reading through the various parts of the file, and it looked like that you had a grasp on that, and you understood that emails are appreciated, but right now the board's rules require hard copies, unfortunately.
No, absolutely understood. That's fine, and we can certainly do that.
Okay, thank you. I just want to go over my notes really quickly to see if there's anything else that I think is appropriate to discuss in light of the issues that Ms. Cadwell raised regarding the current CPG holder not being here today. And if there's anything I think it's okay for us to talk about, then I can touch on that. Otherwise, I think I'm going to have to take this under advisement and consult with the board about next steps. So if you could just give me a moment, and we can go off the record again. Yeah, I think that I'm going to.
Pat, you
Oh, bad money record, yes, please. I think that what I'm going to do is take this issue under advisement and confer with the Public Service Board and get something out. Not exactly sure what it will look like at this point in an attempt to resolve this issue before we do anything in terms of setting schedules and things like that, or trying to talk about witnesses or anything like that. Yes?
May I have another opportunity to talk, and this too can be off the record, about the components of a schedule in a 30 VSA 3 proceeding?
I think I
Sort
don't.
of generically?
Well, it really wouldn't be too generic, because at least some of the interested persons and parties to this proceeding are present here today, and potentially one necessary party is not. I would go ahead and encourage you to speak with Mrs. Area and Ms. Cadwell to stay in touch with the McGuires and talk about that, because that would certainly be something that we would want to work out once we sort through this initial issue.
My request is to talk to the board about the components of a schedule and about in a generic sense, not dates for this proceeding, but rather what the components of a proper schedule would be based on a recent review of the language of the statute.
My concern, Ms. Elias, is that every Section 30 case could be different.
Okay.
But they're very unique. Every time one comes to our attention, there's unique facts to them. Yeah, I can see the idea behind having a generic structure that tends to get used, and I think that to the extent that we would have a conversation like that, it would probably end up saying you're already familiar with the generic structure of the board proceeding.
Thank you.
So,
I tried.
but no, I appreciate that. I don't want to go over a line today that would be not appropriate to go over. But again, please go ahead and start discussing it amongst yourselves, and so maybe we'll be a little bit more efficient when we can get to the point where we can do that. Yes, Ms.
I just want to make I just want to make really clear to everybody in the room and to the board that regardless of all what I call the procedural snafu, AllEarth remains prepared to answer and to fix. This is why we engaged experts as soon as it was apparent that the mistake had been made, and worked with the Division of Historic Preservation to ensure that that we address the issues of concern to them. And my raising these issues today is only to make sure that the board's process is done in a way that the right folks are here, but not to do in no way to delay a resolution of the docket.
Yes, I appreciate that. I do.
Thank you.
Anything else we need to discuss?
I just have one brief thing. I just want, just for clarification, because there's a reference to BHC LLC, and just so that there's no questions about that. There is not an employee of Beach Properties or an officer of Beach Properties or any relationship between Beach Properties and the LLC is either a member or a manager of that LLC. It's the acronym is there, and Basin Harbor Club is there, but there is no relationship between that other than the off-taker and the leaseor with the actual current array as it sits there right now.
Okay, fair enough. All right, if there's nothing else, then we're adjourned, and I will do my best to get some resolution on the procedural snafus and get something out to the parties to keep this thing moving along.
Thank you.
Thank you very much.
Thank you.